Okay, this morning I'm going to, it's 4 a.m. roughly, and I'm up early doing research into New Zealand's constitution. And what I have found is that, which is what I knew anyway, is that New Zealand does not have a written constitution. And a constitution is just a set of rules by which Parliament must act and can't act outside of those rules and must stay within those rules. And we don't have a written constitution. Now, this news report by Newshub, this is one of the reasons this Newshub and TV3 is closing down, because the way they frame their stories is from an activist perspective. This is not a constitutional clash. See the headline there? A constitutional clash. It is not a constitutional clash between Karen Shaw and the ACT Party and the Waitangi Tribunal, because we don't have a constitution, but they want to make it a constitutional clash as though it's some great clash between the government and the tribunal. It is not. In New Zealand, the government is supreme. There is nobody who can overrule the government, nobody who can take the government to task. The government has ultimate authority in this country, but Newshub tries to frame this as though the Waitangi Tribunal has the power to challenge the government over its status as the supreme power in New Zealand. And it doesn't. But let's just see how this story rolls out.
And today took the Waitangi Tribunal to court over its unprecedented move to subpoena the Children's Minister before she repeals a section of the Oranga Tamariki Act.
It's the first time a minister has been required to give evidence or face a criminal offence. Political reporter Amelia Wade was in court.
Okay. Now they're calling it a criminal offence to take a minister to task. These are all very emotional terms to try and frame the Waitangi Tribunal as a very powerful organisation that can push the government around and bully the government. It can't. But Newshub wants to create the Waitangi Tribunal as a Maori activist organisation that can tell the government what to do. And that's what this is about. This is about the thin end of the wedge of tribal rule pushing its way and shoving its way into the New Zealand scene. And it's not. But Newshub is behind this because Newshub is very much for Maorification and for co-governance.
Right across the road from the Beehive, two arms of government are in a constitutional clash.
There it is again, a constitutional clash. It is not a constitutional clash. We don't have a constitution. So they're trying to make this into something that it's not. This is Newshub doing this.
This is an unorthodox, to use the words of the claimants before the tribunal, and actually unprecedented event.
Okay, it's an unorthodox and unprecedented event. In other words, they have no right to do this. They're outside of they should stay in their lane. They were set up in 1975. The tribunal was set up just simply to advise the government on breaches of the treaty. Originally from 1975 forwards, and then it was amended to go back to 1840. And so, it's a body that advises the government. It does not do anything more than that. And the government makes final decisions. That the tribunal can't make decisions on its own about what is going to happen in New Zealand in terms of its findings. It simply presents its findings to the government, and the government makes final decisions. That is it.
7 days ago, we had a nice, workable state of constitutional balance.
That's an activist judge. David Parker was the Attorney General between 2017 and 2023. He was in the Labour Party. He was an activist. He was for co-governance and he was for marification. And during that period of 6 years, they appointed many activist judges, and this is one of them.
Mutual restrict and restraint.
Okay, there we go. This lawyer, for whatever that Maori name is, Matthew Smith, what he says is nonsense. Mutual restraint and respect. No. He says there should be mutual restraint and respect between the government and the Waitangi Tribunal. No. No. The Waitangi Tribunal, like I've said, is just simply an advisory body advising the government, and the government takes what they say, considers it, and either throws it in the bin or acts on it. That is all. But he's trying to make it sound much more than that, and it's not that.
That state of equilibrium has been shattered by the conduct of this minister.
Oh, the equilibrium has been shattered by the conduct of this minister. The minister doesn't have to report to the Waitangi Tribunal, for heaven's sake. It does not have to do this. It's not answerable to the Waitangi Tribunal, but they're trying to make out it is.
Parliament versus the Waitangi Tribunal over the latter's decision to summons the Children's Minister because she refused to voluntarily appear or respond to questions. She lawyered up.
So the basis of the challenge is the coercive aspect of the summons, which obviously has the corollary of being an offence to not meet it.
Okay, so there it is. Look, it's the coercive element. In other words, bullying. There's another word for it. She's being nice and polite, this Crown lawyer, but really Karen Chua and the ACT Party and the government is being bullied and harassed by this tribunal. And this is why Shane Jones and Winston Peters and also David Seymour are going to absolutely overhaul this Waitangi Tribunal and pull it into line once and for all, because it needs to have it done. It's like a naughty child in the classroom.
Tribunal's hearing an urgent claim about the Coalition's plan to repeal what's known as Section 7AA of the Oranga Tamariki Act. That clause requires a consideration of Tamariki's whakapapa and mana when deciding where to place them.
Okay, basically what 7AA says is that Maori children should be in Maori families, and that's the end of it. And Karen Shaw is arguing that no, any children, doesn't matter what their ethnicity is, should be in the best houses, the best homes with the best families, no matter what their ethnicity. And she's right. Because sometimes you can put Maori children in the worst homes just because they're Maori. You put them in a Maori home and they get smashed up, the little kids. And they get into abusive situations. And we know that from the stats, that the Maori record of child abuse and dysfunctionality in homes is massively disproportional to the rest of the population. So you're putting the children in a danger zone. And Karen is quite rightly standing up for that, against that.
Worry is that without that commitment in law, that we're really up to the leadership in the organisation. That's what we're going to be left with.
Yes, you should be up to the leadership in the organisation to decide where the children go, to decide which family they go with. But the O Tamariki, they want to make it law, make it absolutely firm that Maori children have got to go into Maori homes. And Karen says no. Well done, Karen. We're with you on that.
ACT campaigned on repealing it and got it inked into its coalition deal because of concerns it was leading to reverse uplifts where Māori Tamariki were being removed from Pākehā.
Very simply, we want to prioritise the health of a child, of our most vulnerable children.
The Crown says it was a promise the coalition was built on and a decision made by Cabinet.
The tribunal mistakenly thinks the minister is the moving mind, they say. They're mistaken by that.
But Cabinet papers show officials don't support the repeal.
Now, this is interesting. Cabinet papers show that the ministers... the bureaucrats behind or working around the minister don't support what Karen's doing. That is because during the period of Labour 2017 to 2020, TV3, bureaucrats in Wellington have been radicalised. I know for a fact that inside the beehive and inside government departments working around the beehive, that they have been heavily malrified. And one of the great challenges that we have in this country is to get rid of these bureaucrats, because they are the tail wagging the dog. And they're actually making it harder for ministers to get anything done, because they're the handbrake. They are being vexatious, if you like, towards the ministers, not doing what they're telling them they're being told to do. And so we have a real problem inside the beehive, and it's a big, big, big problem. And this is why David Seymour, rightly, is trying to have a clean out. It's like a rat's nest of all these bureaucrats, far too many of them. They've been radicalised, and they are actually being screwing the scrum in Wellington for ministers.
It was argued that's why the minister needed to explain her thinking.
That's what the tribunal is grappling with. How can you have a policy that the minister is putting up to Cabinet in her final Cabinet paper that is so disconnected from the policy analysis of the officials?
Okay, disconnected from the analysis of the officials. Well, what happens if the officials are radicalised? What happens if the officials are all pro-marification and pro-co-governance? And the minister's trying to do the right thing, but all the, quote, officials are actually opposing her and being vexatious. Well, this is wrong. So it's going to take a bit of time to clean out Parliament. And my view is that we just sack these officials. We sack these people that have been radicalised, and we bring in new people, and these new people have very strict job descriptions to do exactly what the minister says, and nothing more, nothing less. That doesn't mean you don't take advice, but ministers have got to be very, very careful to make sure that the advice they're getting is actually advice based on facts and not ideology.
Undertaken in a free and frank sense.
Also at play is the notion of comity. That's the mutual respect and restraint between two arms of government, the courts and Parliament. Each side argued, the other trampled on it.
Comity is a two-way thing.
Justice Andrew Isaac will make his decision on Wednesday.
Well, OK, Amelia, ACT got themselves in hot water on this last week. Any update there?
Yes, this beef extends beyond the walls of the courtroom.
Now, I know Amelia Wade. I've had clashes with her. She is an activist, absolutely an activist.
So when the Children's Minister was first summoned before the tribunal, ACT issued a press release blasting the decision, saying they messed with the wrong woman on the wrong issue at the wrong time. And New Zealand First Minister Shane Jones was also highly critical of the decision. But those comments earned them a public rebuke from the Prime Minister on Friday, who said...
Yeah, Mr. Luxon was very weak and pathetic, not backing up his ministers. And he doesn't understand the situation. This is Luxon. He does not understand the situation. He doesn't understand the tribunal. He doesn't understand how New Zealand doesn't have a constitution, and so on. And so he should have backed both David Seymour and Shane Jones, and he didn't. He did the weak thing and caved in.
Those comments were ill-considered, but that appeared to have surprised David Seymour, who said he thought that concerns were best raised behind closed doors. Now, when the Prime Minister was asked today about the conversations that he'd had with the ministers, he said that the court hearing today meant that he wasn't able to comment because it was before...
Yes, so he wasn't able to comment, and why is that? It's because he put his foot in it, did the stupid thing, realised he was being like a little lily-livered coward and not and ignorant, and so he's backpedaling and saying he can't say anything because it's before the court. Oh yeah, right, good one.
However, that same logic doesn't seem to have applied to David Seymour, who says no, he didn't get a telling off, and he does very much stand by his attacks on the tribunal.
Okay.
Congratulations, David Seymour, for doubling down, and also for Shane Jones doubling down. We need to get behind Shane Jones and David Seymour. These are two great guys doing a great job inside Parliament right now, and we need to give them our full support.
Thank you.